Reality, captured in user-friendly symbols and processed for understanding. The Idea Channel.
I think a lot of people misunderstand what law and economics can do. For example, as a judge, I found out that very rarely was economics of value to what I was deciding. It was of value when I had an antitrust case, but otherwise the Congress or an agency had already made the basic policy decision, and I was carrying it out rather than criticizing it. So that law and economics must not be seen as something that cures all of law's difficulties and problems. It's of quite limited practical use to a judge. It would be of much wider use to a legislature if legislatures were up to analyzing it, because they could be persuaded in an ideal world to decide things with more economic rationality. But that does not seem to be likely, so that law and economics as a practical matter, as opposed to a theoretical matter, is not nearly as powerful as some people think.
In a lot of the cases, as you indicated, you're being asked as a judge whether what the agency did, what the secretary did, was reasonable. But I wonder whether your concept of what's reasonable isn't almost necessarily influenced by your understanding of some economics, so that's things that might seem reasonable to the person ignorant of economics might not have seemed reasonable to you.
I don't think that my knowledge of economics, as such as it is, influences greatly my review of an agency decision for its reasonability. Because I'm aware often of deciding cases and sort of holding my head and saying, oh my God, they've done it again, but nevertheless upholding it.
Well, that's a familiar sentiment. But what you've said bespeaks an understanding of the relationship between the judiciary and the legislature that not everyone understands. I wonder if you can elaborate a little bit.
There's a popular feeling in the country, and as popular among judges as elsewhere, that a judge is basically a policy maker, that judges are wise men, which in itself is a laughable concept, who gather together in a conference room after an argument and decide and debate an issue and then decide. The truth is that usually people come to the conference room with their minds already made up and not necessarily made up on any rational basis. I've had a case in which the question was whether it was likely that a nuclear power plant would be struck by a comet and by an earthquake simultaneously. And the demand was that we have a plan for that eventuality, which is virtually nil. And when I protested to one of the judges that they were making it impossible to build nuclear power plants on no basis in science or economics, the answer was, well, it's a horrible way to die. I said, nobody's died yet. Nevertheless, if they do, it'll be horrible. Well, you have that kind of predisposition, that kind of emotional reaction that typically overrides what you might think that economics would suggest.
Or even law.
or even law.
Well, it sounds then that as though the economics did have some subtle influence, but on you and maybe more than, not on your colleagues, but in that case anyway.
Well, that's why I like to see an antitrust case come along, because there you were free to employ such economic understanding as you had.
Well, you've written about that, about the origins of the Sherman Act and the economic underpinnings. And I take it you're saying now that that means that as our economic understanding evolves, so does the application of the statute.
Yes, and I think you can get that out of the famous 1911 cases against Standard Oil and American Tobacco. You can get a decision that as economics evolves, so should judicial lawmaking.
That may be inevitable. Unavoidable, I should say.
No, I don't think so. It'd be nice if it were unavoidable that judges followed the latest thinking in economics, but it's not going to happen.
And from what you said earlier, I take it you don't have any confidence that it'll happen in the legislature either.
No, I don't.
And does that in any way affect the deference that the judges owe the legislature?
No, I think you have to treat the legislature as though it knew what it was doing. As Holmes said that if his countrymen were determined to go to hell in a handbasket, it was his job to help them. Well, there's something to that.
And we seem to have gone a long way since then.
Yes.
When we move to the Constitution instead of the Sherman Act, do you see a similar role for judges to have an evolving understanding?
Well, sure, but in that case, in this case, judges would have an evolving understanding, supposedly, on the basis of historical research, which discloses what the founders understood themselves to be doing. It would not be an understanding based on the latest thinking in economics, which is economics is by and large irrelevant to constitutional issues.
What do you say to the people? I think there are a lot of them who would say, well, the understanding of the Constitution when it was written is just not adequate, makes the document inadequate to deal with the problems of today.
I'm sure that's true. The question is, what do you do about it?
And then they would say, well, amending it's not practical.
That's true.
So what do you do about it?
Well, unless the Constitution, people who say that usually do not deny that it would be constitutional to address the problem through legislation. So what one could do is legislate to meet circumstances that were unforeseen at the time of the adoption of the Constitution. But it does not seem to me that gives the judges a warrant to legislate themselves in order to cure perceived inadequacies in the document.
Well, you've written about the tendency of judges to do just that nonetheless, not only in the United States, but in other countries, Canada and Israel.
Yes. Oh, yes. And Great Britain is about to get a full load of that.
So how does one create an environment or an institution that prevents that sort of judicial imperialism?
No, I think one prays. Judicial, I'm afraid, judicial imperialism is built into the human heart. You have power, use it. And I don't know what to do about that. The number of ways in which we fall short of having our institutions fulfill the obligations they undertook or they've been handed are myriad. And I don't know what to do about it. I doubt that anybody knows what to do about it. But most people are untroubled by it. They want results, and they don't care how they get them.
Well, that's certainly true, and that's part of the problem that you've described. When you left the court, was it out of any sense that that the role was impossible or unfruitful?
No, it was two things. One was I didn't feel that I was learning anything after a while. So I wasn't building up any intellectual capital. Rather, I was spending any I might have. And the other one was that I wanted to write criticism of the court as we've discussed, and suggest what was wrong with the court's performance, both here and abroad. Now, that's a hope that you may say in light of what I've just said about the courts. That's a hopeless enterprise, that you can't really cure them. And that may be true, but at least you can try.
Well, if it goes to the nature of man and to power, then surely that's a dismal prognosis.
Oh, yes. I think intelligent people tend to be pessimists.
Economists particularly.
The dismal signs.
Exactly. If you could amend the situation, amend the Constitution in some way to address this or maybe some even more pressing matter, how would you do it?
I think I would say, let's see what you fellows can do with this one. To be realistic, I don't think there's any point in amending the Constitution because, in most cases, because judges will simply rewrite what the amendment says.
Don't think it'll slow them down?
No, maybe half an hour. But if I'm right about human nature, then there is no solution to be had mechanically through changing an amendment or changing some other feature of the Constitution.
Well, if I understood you correctly in your reference to Great Britain, the United Kingdom, being about to get a dose of judicial imperialism, I take it as referring to their new Supreme Court, newly established. So would a reintegration of the judiciary with a supreme legislature be a solution or a step in the right direction?
It'd be a step in the right direction. If by that you mean the solution to our problems becomes legislative entirely rather than judicial.
Well, that's been the case in Great Britain with legislative supremacy and a non-independent judiciary. But they don't seem to be in any better position than we are in terms of government and liberty.
I don't know what you mean by that.
Well, it's very hard. It's very hard when one looks at English law or visits the United Kingdom to see that their society is much different as a result of this institutional distinction.
No, there probably isn't much different. The results may turn out to be similar, but at least if we go to hell in a handbasket, we do so legitimately, rather than without legitimate authority.
So by popular election.
Yeah.
Well, judges are not the most obviously attuned to responding to popular will. On the other hand, they are more likely to respond to a minority that's being not just ignored, but trampled in the legislative process. We saw that in the civil rights movement.
Yeah, but it's quite rare. We see now all kinds of minorities claiming judicial relief, and it's not apparent that they ought to be given it by judges.
Who are you thinking of since the civil rights movement? What comes to mind?
Well, I'm thinking of both the women's rights movement and the gay rights movement.
So you're not grappling with animal rights yet?
I'm afraid to open that book.
It's coming. it's been more than 20 years since you left the court, almost 25.
Yeah.
Have you seen further changes in the wrong direction or the right direction in the courts since then? In the Court of Appeals in particular?
Tell you the truth, Doug, I have not been following the Court of Appeals as assiduously as one might, because I'm no longer interested in, well, for example, if you're interested in the meaning of the Constitution, you ought to go back and do historical research and not read the Supreme Court opinions about what the Constitution means, because that will only turn out to be frustrating and wrong. I think the Supreme Court has gotten a little bit worse, and I don't know what the Court of Appeals is like anymore. You can speak to that.
Well, I did look at the Supreme Court's work recently and compared it with its work in the constitutional cases as compared with its antitrust experience, which has been pretty favorable in recent years. They've been economically literate and consistent, and largely speaking with a supermajority in every case. And then I turn to the constitutional cases, and I find that in about 20% of the constitutional cases, not counting the 14th Amendment cases, in about 20% there's now a dialogue about the original public meaning of the text that they're interpreting, which does seem to be if it looks statistically like a fairly recent phenomenon. And I'm wondering if you think if that's a sign of hope or desperation.
Oh, it's a sign of hope. But it's a long way from there to a majority that consistently rules in the direction of the original understanding of the Constitution. In fact, while there may be a sign of hope here, if you look around the world, judiciaries seem to be out of control everywhere. If you looked at the UK, the United Kingdom, and who was in favor of instituting judicial review, a written constitution, by and large it's the left. The unions, academics, and people like that, which means that they expect, based on experience, that the courts will be to the left of the public generally and give them more of what they want than they would get from elections.
I think you showed that was the case in Canada in your book.
Oh yeah, I was invited to speak in Canada, and since I was going to say unpleasant things about the United States, I thought I had to be equally unpleasant about Canada.
Very judicious.
That's right. And Israel, of course, is just out of this world.
And that's untethered by a constitution.
Well, they claim they have a constitution, except that they don't. They have these provisions that were, I think, aspirational statutes or resolutions that were adopted in the middle of the night by less than a majority of the Knesset. But they're treated as if they were, by the courts, as if they were constitutions, which is merely one more testament to their drive for power.
All of the countries you've mentioned, the United States, Canada, the United Kingdom, Israel, have common law, or derived in the case of Israel's common law, from a common law system. Do you think it's a characteristic of the common law countries and not of the civil law countries?
I don't know. I'd like to look into that. I'm not aware, but that doesn't mean much, but I'm not aware of a similar development in France, say. Of course, it may not be the presence of common law or civil law. It may simply be the way they choose judges. That is, judges there in the civil law countries typically start off down a path to become judges, and the rest of them go down a path to become practitioners. So you have a professional class of judges, which may be better than what we have. I've heard it explained, for example, that when you see a contract about a complex matter in America, it's an enormously thick document. In Europe, it would be a much slimmer document. The reason being that American lawyers are trying to negotiate their way out of the judicial system, but by writing these complex contracts. Whereas in Europe, there's somewhat greater confidence in the professional judges than we have in our judges.
The other side of that is that you have judges who've never been in a transaction, drafted a contract, represented a client. And as more and more contracts are multinational because of global commerce, that seems to be a source of frustration to those American lawyers.
Which is a source, you mean?
That the judiciary is so abstract in its outlook.
Well, it may be. The only evidence I offer is the apparent drive of American lawyers to negotiate themselves out of the judicial system, a drive which is not nearly as strong in the continent. Mm-hmm. But I would require more investigation than I have done to be certain of that.
What are you working on now?
I'm working on a book about some episodes I was involved in back when I was Solicitor General. The Agnew Affair, Saturday Night Massacre, and so forth. But beyond that, I would like, given time, to work on the relationship between the culture and the Constitution.
That was, to some degree, dealt with in one of your first books after leaving the court, wasn't it?
What?
Didn't you deal with that to some degree?
Oh, to some degree, yeah.
What was the first book you wrote after leaving the court?
Tempting of America.
Yes, exactly. That was it.
The title I don't understand, but after various titles had been rejected by the publisher, my wife woke up in the middle of the night saying, Tempting of America. So we put that on it, and they didn't know what it meant either, so they ran with it.
Well, for my part, as with the mentality of a first-year law student, which all lawyers retain, I raced to attribute meaning to it and to assume it made sense.
Oh, I do too.
And I think it did. But in that book, it seems to me, as I recall, it's been a while now, that you gave the judiciary a pretty good bill of health for the first 50 or 75 years in terms of their...
That's because the first 50 or 75 years they didn't exercise any constitutional powers.
Exactly. We had men and powers, but not the result that we see today. So how do we explain a variable with a constant?
Well, it may be that, there's some debate about whether the Bill of Rights, for example, was intended to be construed by judges. I don't know the answer to that. I would doubt that the Ninth Amendment, for example, or the 10th Amendment were intended to be construed by judges.
Well, with the Ninth Amendment, you've rather famously described it as an ink spot, I believe. An ink blot.
Yeah, well, I was cursed with the gift for the arresting phrase. I'd be much better off if I just plugged along without trying for a metaphor that would call attention to itself.
Well, I think you were cursed with intellectual honesty.
I would like to think so, but I wouldn't claim it.
Actually, on the Ninth Amendment, it's been suggested elsewhere that it's a rule of interpretation that simply means that the enumeration is not in derogation of common law rights. The legislature can derogate them, but not by reason of their non-inclusion in the Bill of Rights.
Well, that makes sense, and I hope that sensible explanation is adopted, because every so often you see judges who are enamored of the idea of interpreting the Ninth Amendment. Or the 10th. Bob Dole used to carry a copy of the 10th around in his pocket. 10th Amendment has long been dead and cannot be revived unless rights reserved to the states and so forth, unless you are willing to overturn Social Security and Medicaid and so forth, and the civil rights laws and so on. You cannot revive that amendment.
I think you testified in 1987 that because that kind of judicial overturning would be impractical, it just would have to be sort of grandfathered, those institutions, but you didn't compound the error.
A judge has to recognize that sometimes events have moved beyond any practical control by judges. And I think the development of the nation has moved beyond the point where we can try to confine the legislature to the Commerce Clause, for example, as originally understood, or the 10th Amendment or the 9th Amendment. But the fact is, as Ed Banfield wrote, the people who were strongest at the convention in pushing through the 10th Amendment, which is states' rights in brief, as soon as they got into power, began to violate it. And this isn't a practical amendment. You can't run a country with enumerated powers limited. People don't want it. And if people don't want it, they're going to get what they want eventually. Because one of the greatest engines of judicial reform is mortality. Judges die, and you get whatever a new majority wants if the new majority is strong enough and persistent enough. And the New Deal effectively showed us that a judge can't stand in the way of a new majority.
So the power of the court-packing plan was not that it passed, but that it be surfaced.
Did it what?
That it be debated or proposed.
The power of it?
It had the influence. I thought you were suggesting that it had a great deal of influence nonetheless, even though it wasn't enacted.
Oh, the influence, yeah, the power. The court-packing plan may have had some influence or may not, but the fact is judges cannot stand in the way of determined popular majorities for long. They may decide that if, for example, the question is the First Amendment, they should go down fighting rather than give in. But if the question is regulating commerce, they're not about to do that.